Mr. House is here today after failing to appear before this court on July 26, 2023. Bond is currently set at $2,175. This is the fourth bench warrant. He reports that he is employed at Magna Cosma. Last payment made on this account was on July 10th of 2023. That was a $300 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 16th, 2023 at 8:00 a.m. before this court.
Mr. House, you're before the court charged with civil contempt of court due to your failure to appear in a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 16, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Oh, sir, right now I'm not able to post a bond, and I never knew about the court date. Like you said, I've been paying. I even called my child support lady and told her I had a job. I've been complying with you guys. That's why it made no sense. And like he said, this is my fourth bench warrant. I've bonded out 3 times in the last since June to today. I've bonded out every time for child support. I've been trying to comply with you guys. I get my daughter every day. I take her to school every day. I'm trying, so it's like I don't understand. And I might be fired now because I've been in jail for 2 days. I was just working. I just received a second job at the Haven across the street. I'm trying to pay you guys, and I'm trying to stay out of trouble.
Okay.
But right now I don't have money.
What happened? Your last payment was on July 10th. Why did we not get a payment after that?
I told my child support lady that I had a job, so I was thinking that you guys were going to take out of my check already. But I told her as soon as I got hired, which was in July, even before my court date. It was probably like July 15th. I called and told her I had a job.
We don't have any income withholding in place, Mr. Chapman, at this point.
No, Your Honor.
I definitely have check stuff from Magna. I definitely have been working. Like I just said, I just recently got I've been going through the process of getting hired at the Haven across the street, doing the Life Men's Recovery Program, 3rd shift. I was supposed to do a drug test today. And like I said, I'm already in here for another bond. That's why I would appreciate if I could get a low bond for this, so I could be able to get out, so I can keep working and take my daughter to school that I'm on top for.
Okay, so you're in on another matter.
Yes, sir.
Okay. Well, what I'm going to do is I'm going to reduce your bond substantially in hopes that you would be able to be released. I'm going to set your bond in the amount of $300. I'm doing that because you paid up until the July 10th date, and again, it does appear based upon what you said that you are attempting to acquire employment. So I'm taking that all into consideration. Otherwise, your bond would be much more substantial.
I appreciate it, sir. As soon as I get out, I'm going to make another payment. But besides this bond out, I'm going to make another payment.
Okay. Thank you. And we're done at 8:34. Have a good day. And that's all we have, Mr. Chapman, unless you have something else.
I do have some bench warrants for the
Good morning to both of you. You're free to go.
Good morning.
This is the matters before the court for a scheduling conference, and a scheduling conference is where we try to determine what the issues in dispute are, and then based upon that, then we will put in place various dates so that the case would proceed in an orderly fashion. So I'll go to the plaintiff first in each case, then I'll talk to you, Mr. Johnson. Ms. Johnson, what do you believe to be the issues in dispute in this case?
There are several different issues in dispute in this case. From the time I asked Christopher to... Okay,
hold on, ma'am. Let's clarify. I know you've got probably a lot of issues, but the issues in dispute would pertain to custody, support, parenting time, property division, spousal support, or something else. So those are the issues. I don't need all the background and all of that. That'll come out at a later date. I just need to know the basic issues.
Okay. I'm not sure of what Christopher's response was because I was never served his papers, but I am asking for full physical custody of the kids and joint legal custody because
Okay.
over the course of time, I have tried to do like a 50-50 custody, and he's never been able to keep the younger children more than a night.
Okay, let me check with him. Sir, is she stating that the issue in this case is custody? Is that your understanding that there's a dispute on custody?
Yes, sir.
Okay. I'll put down custody, support, and parenting time because they're all interrelated.
Okay.
Do you have any property division issues?
My name is on her van.
Okay. Well, that's easy enough to get that off without being an issue. You're not disputing wanting to take that off, correct?
No,
Okay. Ma'am, do you think that there's a property dispute in this matter?
No, not as far as I'm aware.
Okay, how about spousal support?
I'm not asking for anything.
Okay. How about you, sir?
I'm not asking for anything either.
Okay. Okay. Court will next turn. There is a process through the courts called discovery, and discovery is a process whereby you would acquire information from the other side. You can do that through interrogatories, which are questions that need to be signed under oath. You can do it through a request for production of documents, or you can have various depositions taken of each other or, of anybody else that may be necessary in the particular case. Ms. Johnson, do you anticipate any discovery occurring in this matter?
I'm not sure I understand what you're saying, Your Honor.
Okay, I'll go through it again then. Discovery is the process whereby you acquire information from the other side. You can do that through interrogatories, requests for production of documents, or depositions. Are you anticipating that you're going to need discovery to get information from Mr. Johnson?
Yes.
Okay. And Mr. Johnson, how about you?
Yes.
Okay. What I'm going to do is set October 1 as the discovery cutoff date. What happens when you send out those like interrogatories, requests for production of documents, the other side has 28 days to respond. So you're going to have to get those out right away to have them completed by October 1. So don't delay and think that you're going to wait until, the end of September to serve your interrogatories and that, because you won't have sufficient time to get the answers back then before the discovery cutoff date. So what happens is with setting that date, the court will set October as the date for mediation. Mediation is the process whereby an attorney mediator would meet with you and would attempt to come to a resolution of various items in your case. It is an attorney mediator. They do charge, so you'll each be responsible for 1/2 the cost of the charges. And we'll set that for October. I'll ask you first, Ms. Johnson, is there anyone that you believe that any attorney mediator that you would recommend in this matter?
I do not. I've spoken with one of the mediators on the list that was sent, and she had stated that.
I don't care what she stated. The question is, do you have a recommendation?
No, I do not.
Okay. And Mr. Johnson, do you have a recommendation as to a mediator?
I do not.
Okay. What the court will do is, because of that, the court is required by court rule, I'll leave that blank, and then the mediation clerk will have to randomly assign a mediator in this particular case.
Okay.
Court will set November 13, 2023 at 1:30 p.m. as the settlement conference date. Parties are required to be present unless you've come to a full resolution prior to that time. I'll ask you, Ms. Johnson, is there any questions that you have as a result of, again, this hearing at this time?
No, not right now.
Okay. Mr. Johnson?
I do have one question. Is me and Tabitha supposed to sit in the same room as the mediator?
Well, you can and you can't. It depends. It'll be up to the mediator. The mediator typically has the parties in separate rooms, talks to them, goes back and forth. At some point, he may say, hey, I've got to have the people together to get a resolution, and he might put the people together at some point. I don't know what the mediator will do in this particular matter, but you can take that up with the mediator.
Okay.
I would tell you what we're going to do is we're based upon what you've said, the court has prepared a case scheduling order that will be mailed out to you. You should get it in no later than a week. There are certain dates in that case scheduling order that you have to comply with. If you don't comply with those, it will have an impact upon your case, because if you don't comply, you may not be able to have various witnesses testify. You may not be able to have various exhibits admitted in the case. So make sure that you comply with the dates and the case scheduling order, because it could impact your case. With that, the court will end this matter at 8:45 a.m. Ms. Coy, in this matter, you're before the court charged with civil contempt of court as a result of your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, I do.
I advise you in this matter, you have a right to an attorney. The court, if you request an attorney, the court will appoint an attorney to represent you. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes.
Are you doing so freely and voluntarily?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Okay. The court will find that Ms. Coy does freely and voluntarily waive her right to an attorney. What we're going to do is have Ms. Coy, I'll have you and Ms. Brown raise your right hand. We'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Ms. Brown, when you're ready.
Thank you, Your Honor. Docket 2014-416 DC. The respondent is Natasha Coy. Mrs. Coy, is scheduled today for a bench warrant hearing. She failed to appear March 15th of this year for an adjourned show cause hearing before Your Honor. She has a monthly obligation of $53.50 per month, as this is an arrears only case. Her last payment was October 4th of 2021. That was $10. She's had one prior contempt finding. For a year worth of compliance, Ms. Coy should have paid $642. She's paid nothing. Total arrears through the end of July are $2,038.60. She did book into the Calhoun County Jail on July 31st. She has been court ordered into LEAP back in August of 21, and she failed to attend the program.
Okay. Ms. Coy, do you dispute or contest any of these statements made by Ms. Brown?
I've never heard anything about the LEAP. I don't even know what it is.
Okay.
Other than that, no, I don't contest her testimony.
Okay.
Would you like clarification, Judge?
Yeah, go ahead, Ms. Brown.
Yeah, so back in August of 2021, Ms. Coy was actually lodged in the jail. Friend of the court met with her, released her to participate in LEAP at that time. She was released from the Calhoun County Jail and then failed to attend orientation.
Okay. Ms. Coy, maybe you missed that, but why do you think that the front of the court would have released you if they had not notified you at all about the LEAP program?
I don't know. I don't remember back then. Back then I was taking care of my mom who was dying of cancer, and she since has passed. So now I can get my ducks in a row and go on about my life.
Okay. Okay. Do you have any other disputes with testimony of Ms. Brown?
No, sir, I don't.
Okay. Do you have any questions for Ms. Brown?
No, I don't.
Do you have anything you'd like to tell me, ma'am?
No, sir. Well, I was just hoping to get out by my daughter's birthday on the 15th. And since then, I have been living with my daughter. I've had my daughter ever, the whole time. I've never not had her, even though I don't have custody of her. Her father always dumps her on me. He just brings her and dumps her. He doesn't even give me a heads up, forewarning, nothing.
Well, because this matter is it's an arrearage only case, whether she's with you or not is not relevant in this matter because you're not being charged any current support obligation.
Okay.
Are you working currently?
Yes, I work for United Crane and Rigging.
Work for where?
United Crane and Rigging. I'm a part-time worker for United Crane and Rigging.
Okay. And how often do you work for them?
Well, lately they've been out of town working, or out of state working, so I haven't been going. So the last couple months I haven't been able to work because they're out of state. They work all over the United States.
And the reason you can't go out of state is why?
Because of my daughter. I won't leave her.
How long have you worked with United Crane and Rigging?
Just a couple months. Since last February, when I was bonded out.
And when you work for them, how much do you make on average in an average weekly amount?
Lately, it hasn't even been $100. So.
Okay. Have you sought out or pursued any other or more consistent employment?
I have medical problems, and of course, I just took care of my mom who died of cancer. So I haven't had the opportunity to.
Well, you've been with United Rigging, you said, for a couple months, and then they've been out of state for a couple months or as well, at least a few months. And
Right.
So during that time you were working or you could have worked. And did you pursue any other employment during that time?
No, I didn't.
Okay. Why is that?
Because I had my daughter 24 hours a day, 7 days a week.
Okay. Well, a lot of parents work and they have
I'm
kids.
disabled. I'm disabled.
Okay. But you're working.
I'm disabled. I'm not supposed to be working. And I only work part-time when I can.
Have you provided any documentation to the front of the court about your disability?
Yes, I have.
And when was that?
That was over a year ago. I'm unable to obtain or maintain work, mental health.
What is it?
It's my mental health. I'm unable to obtain or maintain work.
Your Honor, front of the court has no medical documentation on file.
Okay.
It was through Summit Point. I turned it in to them.
Turned it into who? Summit Point?
No, I turned it in from Summit Point to them in the basement here.
What?
I gave it to the people at the desk at the basement, in the basement of this courthouse.
Okay.
I can provide more documentation if I need it.
Well, the court is going to order that you provide that medical documentation. Unfortunately, and I don't know what the problem was, but as you can understand, the front of the court has thousands and thousands of cases. So when you provided documentation, it might have gotten in a different file or something of that nature. So it doesn't appear in your file. And I'm sorry for that problem, but again, it's understandable with the amount of cases that they have that you might once in a while have some problem. The court, however, does note that the court does believe that back in August of 2021, you were ordered into the LEAP program. That would have helped you to acquire employment if there was employment available to you based upon whatever disability you had. So they would work with you and attempt to find employment that would, again, I guess you'd say coordinate if you would, or that would be sufficient to address any disability that you might have. But if you don't participate in LEAP, then obviously you're not going to be able to get that assistance.
Right.
Your Honor, if I could, please.
Go ahead, Ms. Brown.
The friend of the court would like the court to be aware that Ms. Coy did submit back in 2021 a printout that she had appeared at Summit Point. It was a printout from Summit Point. It did not speak to her ability to work, to maintain employment. It was a printout from Summit Point that she had attended an appointment there.
Ms. Coy, you heard that? So what you're going to have to do is you're going to have to submit documentation that states that because of your condition, you are not able to be employed. Not simply not simply that I went to an appointment and I had an appointment there, but it's going to require a diagnosis and prognosis of the fact that you're not able to work.
I understand.
You said that have you been receiving disability?
No. No, I was denied, so I have to get an attorney and go after it. Or reapply, something.
If you've been denied, you're going to need to seek out an attorney and again appeal that denial.
Okay.
Anything else that you'd like me to be aware of?
No, sir.
Ms. Brown, you said that there was a prior contempt finding in this matter, and how long, what was her jail time at that point?
She was not sentenced to jail, Your Honor.
Anything else, Ms. Coy, that you would like me to be aware of?
No, sir.
In this matter, the court notes that matters before the court as a result of the failure to pay, that the last payment in this matter was in October 4th, 2021. So well over a year and a half, that it is an arrears only case with a minimal monthly payment of $53.50, that back in August of 2021, that the respondent was sentenced to participate in the LEAP program. She has not done that, that would in fact help to make her employable, or as she states that she has a disability. She claims to have a disability, a mental health issue, But the court would notice she also testified that she's been then denied Social Security disability in this matter. She has not pursued any sort of appeal or taken any other action as a result of that. She has been employed recently as of February with United Crane and Rigging. And she states that she works part-time, apparently with them, makes about $100 a week when she does work. However, recently they've been out of state on different jobs that she's not able to take because of the fact that her daughter is in her care. So notwithstanding all of that, the court does note that she has the present ability to make payments in this matter, that she's failed or refused to do so, that she has not pursued other courses of action that would in fact make her employable. And as a result, the court would find that she is in contempt of court in this matter. Ms. Coy, is there anything you'd like to say before sentencing?
No, sir.
The court could sentence you, Ms. Coy, up to 90 days in jail, being that it is a subsequent contempt finding, but court will not do that. And I won't do that because initially you were not incarcerated on the prior contempt. What the court is going to do, however, the court does believe that, again, to impress upon you the importance of complying with the orders of the court, that, again, some jail time is necessary. The court is going to sentence you to 21 days in jail with credit for 10 days served. The court will put in place a purge amount of $500. If you're able to post the purge amount, you would not be required to spend the remaining time in jail. Do you have any questions?
No, sir.
Okay, thank you. Court will end this matter at 10:26 a.m. You're free to go. Have a good day.
2435 DC to Alyssa McCoy versus Joshua Brown, attorney Teresa Reiser for defendant.
Okay. Good afternoon to everyone. We are appearing virtually, and I want you to know this is a court proceeding, and you need to conduct yourself as if you were personally in court. Appears that we have good connections, so that's not a problem. I will tell you, everyone will have an opportunity and have multiple opportunities to speak, so do not interrupt each other, other witnesses, and especially do not interrupt me in this matter. If you do have, do not make comments when someone else is speaking or testifying. You'll be given an opportunity to respond. If either party, if any of the parties engage in offensive conduct, interrupt the court proceeding, you could be held in contempt of court and go to jail. So just govern yourself accordingly. Ms. Reiser, your client has filed the motion in this particular matter. Do you wish to make an opening statement or proceed to proofs?
I can proceed right to proofs, Your Honor.
Okay. Ms. McCoy, you have an opportunity to make an opening statement, or you can reserve the opening statement or waive opening statement. Do you have any opening statement, or are you not?
No, sir.
Okay. Okay. Ms. Reiser, you can proceed. Go ahead, Ms. Reiser, when you're ready.
So, Mr. Brown, I'm going to ask you a series of questions. If at any time you can't hear me or you don't understand the question, just ask me to repeat it, okay? Or if you can't hear or understand the judge, just ask us to repeat it.
Yes, ma'am.
Okay. Mr. Brown, you were never married to Miss McCoy, correct?
Correct.
When approximately were you in a relationship with her?
Approximately 2015 to approximately end of 2019.
Did you believe your relationship was monogamous?
I did, yes, ma'am.
And did Miss McCoy have a child during the time that you were together?
She did, yes.
Do you know approximately when that child was born?
Approximately August 2018.
Okay. And did you believe you were the biological father to that child?
I did, yes.
And why did you believe that?
Because we were in a relationship when the child was conceived and actually when the child was born.
Okay. Because you believed you were the biological father of that child, did you sign an acknowledgement of paternity acknowledging that you were the child's father?
I believe I did, yes.
And is your name on the child's birth certificate?
It is.
And were you ever ordered to pay child support for that child?
Yes, ma'am.
And approximately, if you know, when did you start paying child support?
It had to have been November 2020 when I started working at Prairie Farms.
Okay. Did you ever exercise parenting time with the child?
I did.
For approximately how long?
That would have been when the child was first born in 2018 and early 2019.
Okay. Did you later learn that you may not be the biological father of that child?
I did in the end of 2020, I found out.
Okay. And how did you learn that you may not be the child's biological father?
So I was incarcerated the year 2020. And during that time, my father and mother they went to an attorney and they asked to get grandparent rights, or if there were to be that, from what I understand from my parents, because they were having a hard time contacting Talisa to see Ewan at times. So the attorney that they went and seen, they said, well, first you have to go take a DNA test. So when we do go to court, we have something to stand on. So they went and they did the paternity test or DNA test, and they came back that it was less than 1% chance that they were the grandparents. That's actually when I got out of jail. That's how my dad waited till I got out of jail to tell me that information. And so that's how I found out he wasn't going to be mine.
And what did you do when you learned that you may not be the biological father?
The first thing I did was my dad paid for a consultation fee with an attorney, Cindy Thomas, and she told me to sever all ties with the child immediately, which it was a year. It was already a year I hadn't seen him. I was in jail. Furthermore, I didn't see him or have any communication with him anymore from then on, based on her counsel.
Okay. And did you ever take a DNA test?
I did. I took my own test, so that was 2020 when I did that.
Okay. And what were the results of the DNA test?
That test said it was negative, that it was a 0% chance that I was the father of Ewan.
And then you submitted to a second DNA test at the order of this court, correct?
Correct.
And what were the results of that DNA test?
Also, that one said there was a 0% chance that I was the father.
Okay. And after you learned that you weren't the child's biological father the first time, did you said you cut off all ties? You ceased exercising parenting time?
I did. They were already. I hadn't seen him because I was in jail, but I did. I had no more. I exercised no more parenting time with him from then on.
And so, when was the last time you had contact with the child?
That would have been 2019, around October 2019.
And approximately how old was the child at that time?
He had to have been 1 at the time.
And do you know how old he is now?
He has to be 5 now.
Okay. So do you believe it would be a fair statement that say you had a relationship with the child for only maybe a year, very early on in his life?
Yes, ma'am.
And do you believe the child is bonded with you?
No.
Do you have any sort of relationship at all?
Not at all.
Do you believe any type of harm could come to the child by revoking your paternity?
No, not even the support that I provide to Lisa, because she does. We neither one of us have legal guardianship of him anymore.
Okay. So, Your Honor, it's clear that no harm will come to the child if Mr. Brown's paternity is revoked. It's not against the child's best interest to revoke his paternity because the child most likely doesn't even know him. So Mr. Brown requests that his paternity be revoked, that the order of affiliation be set aside, that the uniform child support order be terminated back to the date of the filing of this motion, and that the parties take the necessary steps to remove his name from the child's birth certificate.
Okay. Ms. McCoy, you have an opportunity to question Mr. Brown. If you wish to do so, do you have any questions for Mr. Brown?
No, I know the whole point of this court date is to get, to terminate his child support order. So I just leave everything as is, and that's okay.
Okay.
We did provide a proposed order, I believe, to the court on July 19th.
Okay. Any other witnesses, Ms. Reiser?
No, Your Honor.
Ms. McCoy, do you wish to testify?
No, sir. Regardless of, what was said, my argument it doesn't matter. You know what I mean? He deserves, to not pay child support anymore,
Okay. Court will note that the court has heard the testimony today by Mr. Brown in this matter. Court will note that I will, in fact, take that testimony as well as the defendant's verified motion to revoke paternity, set aside order of affiliation, and to terminate uniform child support order that was filed in this matter previously. That has some additional information that was not testified to today, but it is verified, and the court will consider that. Court will note as well that the mother, Ms. McCoy, is present as well. She has not offered any testimony at this time. It has not offered any testimony to refute or dispute any of the testimony of the defendant. Court notes, Ms. Reiser, I guess I'll ask, you haven't, but do you seek to have the DNA test report admitted as an exhibit?
Yes, Your Honor, please.
Okay. Well, in this matter, it's very clear that, again, the parties were engaged in a sexual relation at the time of conception and at the time of birth of the child. However, during the defendant's incarceration, his parents pursued a DNA test, came back at, he said, less than 1% probability of paternity. He was incarcerated at the time. He was not informed of that, he said, until such time as he was released from incarceration, which would have been sometime in 2020. He then proceeded to get a DNA test, which in fact determined that he was a 0 probability of paternity. He then subsequent, as a result of these proceedings, had a second test, and that test has been admitted as Defendant's Exhibit A. It's a DNA test report from DNA Diagnostic Center, dated 6/21/2023 by Deputy Kumar, PhD, and attesting to the fact that the test was of the defendant and the child in this matter, who was, I would just refer to by initials, he's EAB, date of birth, August 4, 2018. And that shows a probability of paternity of 0%. Court notes that the court then does have to look at and determine whether it's in the best interest of the child to revoke paternity, or in this case, the acknowledgement of paternity. Court notes in looking at the factors, first, whether the presumed father is stopped from denying parentage because of his conduct. The court will note that the court has not heard any evidence which would have stopped him from denying, again, parentage. He believed, based upon representations of the plaintiff, that he was, and only found out subsequently when he was incarcerated, or actually after he was incarcerated. He then took action at that point to have a test done. He also severed any relationship he had with the child. He only had a relationship for probably a year or less, and the child is 5 years old now. And as a result, the court doesn't find any issues as it relates to that. The next factor is the length of time the presumed father was on notice that he might not be the child's father. That again occurred in 2020 when he pursued the test results, and then subsequently in these proceedings. The facts surrounding the presumed father's discovery that he might not be the child's father, we've already addressed that. Next, the nature of the relationship between the child and the presumed father. In this matter, we've testified they had a relationship for a year or less. And again, the child is now 5 years of age. Next is the harm that may result to the child. Obviously, there's been no relationship for almost 4 years over 4 years at this point. So the court will determine that, again, there's no harm in this particular matter. Other factors that may affect the equity arising from the disruption. Again, court does not find that there is a father-child relationship, so there would not be any problem with the equities arising from the disruption, and any other factors determined to be appropriate. Court takes into account all of the testimony that was presented in this matter, as well as in the verified motion. In this particular case, when the court does, the court will determine that the there's not issue of the defendant in this particular matter, that the child is a child born out of wedlock, and the court will grant the petition in this matter to revoke the acknowledgement of paternity in this matter. Also, to set aside the order of filiation previously entered, and to terminate the support obligation that the defendant has had in this matter since some time back in this case. With that, the court will enter the appropriate orders. Ms. Reiser, is there anything else that you believe the court needs to address or has not addressed before we conclude?
No, Your Honor, I just have one question. Is it sufficient to provide a copy of your order to the friend of the court, or do we need to do a new uniform child support order?
No, you should be able to. This one will terminate that. You
Okay.
should be able simply to provide them with a copy of it. I guess if they are requesting something else, that you could pursue it at that point, but I would think that it obviously is a court order, that they would comply with that and recognize the court order.
Okay, thank you.
Ms. McCoy, is there anything you believe the court needs to address or have not addressed before we conclude?
I know that you had mentioned it. I don't know if it's required or whatever, but my mom had done a DNA test on the actual biological father, but he passed away. So I know that it doesn't matter. It doesn't have anything to do with, terminating Josh's parental
Correct.
order or none of that. But I just wanted to let you know that in case that was, a question that popped up. Like,
well, the only thing that might be is obviously if he's deceased, it may be of importance to you, because if you can establish paternity on that individual, the child may be entitled to various benefits as it relates to that individual.
yes.
Court will note too, thank you brought that up, that your mother, the court would note that the plaintiff's mother is currently the guardian of the minor child, and pursuant to order of the court will note that she did file an answer to the petition this matter where she did not dispute nor contest these proceedings. So I just wanted to mention that on the record as well. So that will conclude this matter. We'll end at